And now I would like to invite our last keynote speaker, Mr. Tarun Khurana, co-founder and partner, Khurana and Khurana IP Attorneys. With 18 years of experience, Mr. Khurana is also co-founding partner of its patent research and IP assets management firm, IIPRD. Tarun is among the top 12 patent prosecution practitioners in India, as ranked by IAM 1000 and also by IAM 300 strategists, and is a regular speaker at numerous institutes and corporates, including the international conferences. He has a master's in software systems from BITS Pilani, bachelor's in law, and an MBA from IIM Lucknow, and is in pursuit of his PhD. Mr. Khurana will address us on the legal standards of connected vehicles, a perspective. Over to you, Mr. Khurana, and a very warm welcome to you.
All right, fantastic. A very good afternoon, everybody. Saturday afternoon, tough times. Thank you very much, Anuj, for having me, and pleasure being here. I wanted to share a presentation, but I think by the manner in which the previous session was conducted, I thought I'll rather speak up rather than sharing the presentation and being formal about it. A lot of legal issues. I mean, my intent, I come from a law firm background, and I'm one of the founding partners at Khurana Khurana. So the intent of the session was to talk about various legal issues that might come up in the connected vehicle space, connected vehicles industry space. In that context, we do a lot of representation for entities like Daimler and Ford and a few other entities in the vehicle space, not only on intellectual property but on legal issues in general. And there are tons of them. There are issues on data, as I was hearing in the previous session, who owns it, how to sort of transpire the data, how to manage the data, how to comply with data which is actually being stored in, say, the European servers where GDPR would essentially be taking care of it. What happens when the data protection bill in India gets passed off? There are also issues of privacy, cybersecurity, and all of those. In the next 10-15 minutes of my talk, I wanted to rely more on intellectual property issues that come up usually in the connected vehicle space and wanted to emphasize on two major types of intellectual properties, one being patents and the other being copyrights in the form of open source licenses that need to be very carefully looked into before a company that sort of wishes to either launch a vehicle or become an OEM or essentially have a software technology that would get embedded into one of the vehicles. We've been filing applications on the patents side, and we file almost about 200, 300 patent applications only for certain companies in the automobile space. And of that, a good 30% of the portfolio is in the autonomous and the connected vehicle space. And they vary from vehicle to vehicle. They vary from vehicle to infrastructure or types of connectivities that there are. A lot of them are guidance level patents. A lot of them are navigation oriented. Some of them are obviously communication protocols being established out. But although the litigation and although the enforcement side in the vehicle space is largely concentrated in the US market, connected vehicles has in the last couple of years seen significant litigations in the US. There was an entity called Voyage, which sort of got sued by a company called Success on certain patents, which were very critical to the launch of the vehicles that Voyage was doing in the autonomous as well as connected vehicle space. And by virtue of injunctions being granted, there was a lot of damage, not only monetarily, but also on the production of Voyage vehicles that happened solely because of the patent portfolio that was existing on, that was being assigned to Success, and Success essentially did not allow to give a license at that particular stage. So there was a big litigation on that front. There was also another litigation where there was American GNC technology company that focused on guidance and navigation. They sued Toyota over autonomous car navigation patents, and that also became a fairly hot bit as regards US patent litigation scenario is concerned. With the number of patents growing in India from automobile companies, we see Mahindra and Mahindra, we see Ford, Daimler, Toyota, all of these companies obviously increasing their filings. Just barring this last one quarter, we've been obviously seeing an increase in the last 3 years in the total number of patents being filed. And most of these patents have evolved from basic mechanical engineering level improvements to a lot of IT software related technology improvements. and therefore have become very critical. A lot of these patents and their families, for example, even in the US and Europe, have been declared to be standard essential patents, which means that if you were to actually launch a connected vehicle tomorrow, which was using, for example, a Daimler's patent on how to identify surrounding objects, or use a Volvo's patent on how to maneuver an autonomous vehicle. I have a whole diagram we've sort of illustrated in one of our landscape reports that we have done of how many patents there are, what are the key patents, how are they getting, how are they covering various components of an AV or of a CV. And therefore, if you look at the whole landscape, it is a very scary activity where tons of patents are being declared and by companies at ETSI and at other standard bodies which are being set out of how they'll communicate under 5G protocol, under various other Bluetooth protocols, under Wi-Fi. Tons of, they're all unimaginably ranging from focused on audio technology to security to voice recognition to self-parking. So we see a lot of not these Indian patent applications, but their corresponding parent applications in US and Europe being declared as standard patents. And by virtue of them being standard, anybody coming into India with an entity or a car which basically is declared to be having some intelligence, some connectivity with other cars or with an infrastructure would have to do a freedom to operate exercise to ensure whether they're actually relying upon or are infringing upon a declared standard essential patent. And if they are, then they'll essentially have to take a license, not only by other, so these patents are not only being filed by large vehicle manufacturers, but also by tech companies like Ericsson and Huawei and Qualcomm, and their semiconductor chips and technologies get implemented or integrated into such vehicles, and therefore licensing on such SEPs, which currently, if you look at in the Indian patent landscape, is more restricted towards the mobile computing device segment, where Dolby has filed a few cases in the last few years. We've seen Ericsson filing a few cases as well. So in that space, obviously, as India gears towards the connected vehicle and the EV and the AV space, we do surely anticipate more litigation in the automobile segment as well. The second issue that I wanted to touch upon was from an open source copyright standpoint. There was a discussion in the previous session also on Android platform being used. But I think it's not that simple. We consult a lot of entities in India, a lot of manufacturing companies that are making their infotainment systems using open source software without really realizing what kind of license is that AV based on. They'll have to look at. It's very critical for when you're developing a software based on OSS, which is open source software platform. You will have to see what kind of licenses are they complying to. Is it a copyleft license? Is it a weak copyleft or a strong copyleft, or is it a permissive license? Now, for example, Apache 2.0, on which Android relies upon. So Android is based on an Apache license, and Apache is a permissive license, which means that whatever source code that you've taken from the open source is obviously open source, but the subsequent code that you've developed over and above the source code, you will have to give it under certain terms and conditions, which can be different from the terms and conditions under which you got the original OSS. However, if your systems are built up on Linux, for example, or is based on a GNU platform, which is a strong copyleft, then in that case, what if you've got 100 lines of codes from a license which complies to a strong copyleft, and you've made 1,000 lines based on those 100, all the 1,100 lines have to go back in the public domain, and you have to declare it. And this is exactly what happened with Tesla when they declared all their source code, a significant part of it. I can share the presentation separately if required, but Tesla had a big issue in 2013 of June, where they were accused of developing and using open source licenses which were GPL based. Most of the GPL licenses are strong copyleft, and they were accused of not sharing any of the source codes that were developed on it. And as a result of it, by virtue of that litigation, they had to come out and release some of their source codes on GitHub. GitHub is a platform where entities can come and put their repository of the source code. So there are certain links on which most of the source code on which Tesla had developed their open source platforms using the GLA license. So they might have done some development using GLA, some like done, for example, on Apache. So for an Apache, there is no problem because the source code that you incrementally improved on or developed on your own, you could really license it out on a commercial basis. But when you're using a strong copyleft, you really can't even license it on a commercial basis because you have to disclose the complete source code back to the society on which from which you got it. So we really have to, I mean, there is a lot of in-depth understanding that entities need to understand, that need to develop on guiding their development teams, because most of connected vehicles in AV is software oriented, and you have to understand what platforms are they using. Are you doing a due diligence to check whether there is what kind of licenses are you complying to? Are the developers being monitored enough to ensure that there is nothing from the open source being taken inadvertently, even in spite guidelines being put across by the companies? So unless such due diligence and audits are done, you will always be under the impression that you are all safe. But tomorrow, when there is a third party litigation which is filed up stating that here is the proof that you've actually used an open source platform and you've really not disclosed your source code back to the society, you will be mandated under the license terms of such copyleft practices to come and disclose. So these were the 2 points that I wanted to essentially harness upon. One was on the patent side, that I think it's high time that Indian entities have a strong portfolio that they develop in the AV in the connected vehicle space, and not only develop it and leave it there, but also declare as many of their patents as possible as standards. Because I think once they start declaring it, because there is no examination per se of a standard that is done by ETSI or by standard bodies. It's the suo motu practice or the suo motu initiative of the owners of the patents or the patentees to come out and disclose that according to you, it is a standard patent. And tomorrow when there is a litigation, then the other party will have to prove that no, this is not a standard which is mapping to an already established practice or to a standard which has already been, for example, a 5G standard that might have been laid out on. So you will have to establish it at a later stage, but at the time of declaring it, there is no assessment that happens of such standard essential patents. And therefore, I think it's like in the telecom space, there is TSDSI, which is the Indian community that has come up together, like companies like Tejas Networks, Reliance Jio, that have come up together and formed a consortium to declare standards in the Indian context. I think it's important that even in the automobile space, companies come out and they file patents, obviously, but not only with an intent of trying to be defensive around them, but from an intent that tomorrow when there are enforcements being done by Toyotas and by other large companies, there is a cross licensing opportunity where you also have a handful of patents which have been declared as standards. So these were the 2 things that I wanted to talk about, and I'm happy to answer any comment that there might be. As regards the presentation, I can email that to Anuj, and he can pass it on to the colleagues here.
Sure, fantastic. I think Tarun, this was a very informative session of yours. You know why? Because a lot of times techies, a lot of times companies, entrepreneurs, they invest so much of time, effort, innovation in creating something, but they don't really take care of the legal protections, and that's when they have to pay a huge price for that. Like the example of Tesla that you shared, that they had shared open source stuff and then they did not share the code. Probably somewhere it was a huge oversight, and a very basic one. Even a first year law student would have told them, hey, what you do is not right from the start. So having this legal orientation is a prereq to avoid costly litigations thereafter when you make it big. So you should start right. And so IP compliances are extremely important to have in place when you're creating something, especially where the protection of safety, security, privacy are huge debates in connected vehicle space.
Right. Absolutely, Anuj.
So any questions you might have, friends, please feel free to ask Mr. Tarun Khurana. He's one of the top IP lawyers of the country, and he's doing work for a lot of OEMs. So he'll be happy to share, his thoughts. Okay, so we have a question. We have by Mr. Nitin Dhingra. Please ask your question.
Yeah, am I audible?
Yes.
Yeah, hi. Very nice presentation. Very informative. I just have one question. That under Indian IT laws also the usage of open source is as similar to what we saw in Tesla case? Is it declaration sort of things are essential, or what is the scenario in India?
No, Nitinji, I think it's a matter of aggressive, role being played by certain NGOs. Because if you look at open source litigation worldwide, unless there are cases like Sun Microsystems and when Sun was bought by Oracle 5-6 years back, and there was a big litigation between Google and Oracle. If barring these kind of litigations where there are company to company, most of these otherwise compliance litigations are initiated by NGOs. So there are tons of US-based software open source regulators that because they're funded by their competitors, they file tons of litigations in the US against companies that potentially use open source platforms to develop, and even if there is a slight breach of their license terms, they will be sued upon, and then they will have to compensate either through a settlement outside the court, or they'll then have to declare all their source code. So by virtue of the declaration of the source code coming back to the public domain is such a detriment to the companies, because they'll have to declare the whole source code. They cannot say that these are the 10 lines of code or 1,000. These lines of codes are millions of lines of code, and once they have to really bring it to the public at large, just imagine the competitive edge that they've lost, because all the developers would have invested thousands of dollars in their development cost, which is now accessible to global companies worldwide. It is just a matter of time, trust me, that there are, maybe one day when I retire and I don't have commercial aspects to look into, I will probably definitely, if somebody has command over, and I've counseled quite a few automotive companies on this front as well, and we go into very, very detail. This is just a 15-minute discussion, but otherwise, we go into the license terms, each and every license terms of what kind of read rights do you have, what kind of write rights do you have, what kind of sharing rights do you get. These are hundreds of pages of licensing agreements, and it is a matter of time that there are large NGOs that come that are knowledgeable enough in the software open source compliance platform. There's not much money in India from a judicial standpoint. You will hardly see that there are Indian courts granting damages of 5 crores, 6 crores. It's a matter of couple of lakhs, which is nothing, at all. So by virtue of, and the US is on the other hand, billions of dollars of damages. So by virtue of the stakes being too low in India, you don't see an upsurge on these things. But otherwise, there are 9 out of 10 companies that are not complying with open source. I can say that with a lot of confidence, not only in the automotive space, even in the general product development space. There are developers who, if they're not able to define a particular logic, or they're not, they have the logic in mind, but they're not able to get the expression of it, or they want an API to it, they'll just go to Google and type it out, and they'll use that API without even bothering to check whether that API is what license does that API rely upon. If that API has been developed using a GPL license, and then you use that API in your source code, just a one-line API, then you've gone. The entire source code becomes GPL. That's the fundamental reality of a open source, of a strong copyleft program. If once you use even 10 lines and you write 1,000, the entire code has to be disclosed out. So I think it's just that enforcement in India and the knowledge on these aspects is not comprehensive enough. Otherwise, you will see a plethora of litigations in India against Indian product companies across sectors.
Great. That was very informative, Tarun bhai. So Tarun, when do we see, as you mentioned that, high courts in India, usually the IP cases mostly go to the high courts, because also that, I don't know about the pecuniary jurisdiction now, but at least earlier, because they would have the judges in the high courts and above would have the knowledge, acumen of, entertaining those cases. But when it comes to something as technical as one line of an open license code put and the entire code is gone, what is the awareness level of the judiciary, of the bench? What kind of measures and reliefs can be taken? If challenged.
The point is, these issues don't land up in the court right now, because, as I said, these issues are usually, even if you look at the US, you look at compliance issues. If you look at the Tesla example, this Conversency was not really a company. It was more of an open source code enforcement agency. A lot of them are, even if they're for profit, their main business is that. So they have algorithms that they have developed which will look at a particular module or a functionality of your software executed, and will then be able to prove to the court of law that this module could not have been made without this API. And this API was based on GPL. And by virtue of GPL, they should have disclosed in the source code. That's how they backtrack it off. Unfortunately, in India, I mean, the judges have their own limitations. You know, I mean, I don't want to go into it because that wasn't really the agenda. But there are, I mean,
we will not get in a contentious area any which ways. We don't want to.
Long way to go. Yeah, I mean, judges. I mean, everybody in the IP fraternity has to get most of them. I mean, I don't. I mean, naming will become very difficult. But there was a very, very super senior lawyer that we went down to for a copyright litigation matter for which we had filed an SLP in the Supreme Court, and I tried to explain to him on copyright infringement in the software space, and he just absolutely had no idea about what a source code is. And it took me 15 minutes or 30 minutes to just explain to him what a source code is, how a binary file is generated, how an exe file is generated. He just absolutely had no clue. And if he didn't have any clue, how difficult would it be for a judge to appreciate it?
So even if he would have a slightest clue, what about the bench?
That's what I'm saying. You can imagine where we are at this point in time, and things have to go a long way. Absolutely.
All right. So any other questions for Tarun Bhai on the legal aspects of connected vehicles? Please feel free. Okay. So Tarun, I have one question. All right. And that question, now we change a bit from source code to liability. All right. Suppose there is a vehicle, it went to the service station for a routine service. And during that routine service checkup, inadvertently or advertently or recklessly, there was a port which was left open in the entertainment system of the vehicle. The car is delivered shining, nice and shining. The customer is driving the car down the highway. All of a sudden, there is a hack attack on that vehicle because those hackers got access to the steering system, braking, music system, pre-tensioners, airbags, ignition. All these systems they got access to through the open port which was left inadvertently open in the entertainment system. And what I'm quoting is a real life example, 2015 Jeep Cherokee US. Where does the liability lie now?
So it would have to be checked upon specifically what the timing of the port opening was. And if it was by the user and if we did not close it, and if under the respective guidelines or the standards or the protocols established by the vehicle manufacturers, and I'm sure if it happened in the US, there are numerous guidelines. Everybody has compliance codes as regards what the liability of a service of a guy who does the service, as an entity, the company that does car servicing, are they supposed to check whether the ports are closed at the time of entry and at the time of exit? If it is not their responsibility to check it, then you can't put the liability on that chap. But if in one of the agreed to terms, I'm sure there's a SOP, right? Of whenever I'm not in India, but in the US, there'll be always an SOP of what the entity that does the servicing has to do. So if they have to do 5 different things, check that the engine ignition is off, petrol, this, that. And if one of those checks is to check that the infotainment system is off and one of the ports is not working and port level checking has to be done, then it's a clear liability. Then you can't run away. But if it's not, then, the liability being on at least on the guy who did the servicing is out of context, if it's not specifically and explicitly mentioned in the SOP. And second, obviously, if it's a user, then there is no question of liability because he has already suffered it in totality. Whether it is on the vehicle manufacturer or not, again, will have to be dependent on the specifications. So this decision will not be a very, very difficult one to make, but will essentially require a very clear check on the SOPs laid out for the service, for the entity that does the services, as well as the specific product manual specifications of the vehicle manufacturer. I think these two documents will be have to looked upon very closely, and you will be able to make certain good.
Fair enough. And what about those brilliant hackers? What about them? How would they be tried? What would be the repercussions they will face, say in US and in India, if it happens?
I mean, it's a dead game for them, obviously. I mean, if you're able to track them out and fetch them up, whatever is the appropriate criminal procedure code in the US for these kind of crimes will be applicable to them again, depending, and those liabilities will obviously increase exponentially depending on the damage that it has caused. So if it has caused an accident, then obviously it's a massively higher damage compared to if it only allowed the vehicle to sort of stop working normally or stop functioning, or the engine wasn't getting on, or some other issue that didn't really escalate to the level that it could become very, very damaging. So that would depend on the extent of damages caused. But obviously the bare minimum threshold by virtue of the hacking actions will be governed. I think these are fairly settled practices, Anuji, and therefore penalties follow accordingly.
Well, great. I think we should probably try explaining this to the investigation officer at the local police station that the car got hacked, and I'm sure what kind of a look he will have on his face when we go to file and lodge an FIR. All right. So, any further questions, friends, or do we wrap up this in such an interesting session by Mr. Tarun Khurana? All right. So it seems that they're all clear, and surely they've all enjoyed your session. They seem pretty mesmerized. So Tarun bhai, people have requested for your presentation. If it's in the public domain, if you wish to share, you can send across us a PDF. We'll be very happy to put this in the WAF think tank section on our website. And we'll also share with the automotive stakeholders, mobility players across the world, 125 countries, and they can all benefit from your knowledge. And I'm sure they can also reach out to you if they need even more.
Absolutely, I'll do that, Anuji.
Great. Thank you so much, Tarun bhai. And so friends, if you have really liked this session, we need your feedbacks now. Let's thank Mr. Tarun Khurana, founding partner of Khurana and Khurana IP law firm. Let's thank him. If you really like this session, show it now.
Thank you.
Thank you. So over to you, Anita ji and Mohini ma'am.
Thank you so much, Mr. Khurana. That was a very informative session, and a lot of opinions, a lot of doubts also cleared. So thank you so much, and once again, I think we'll. I think that was a really good note to end on. Thank you so much, sir.
Thank you, ma'am. Thank you for your time. Thanks so much.
Thank you.